And so, Mr. Wood, you're the party here that has been sued. Ms. O'Hara, you're the one that filed it. Is there a reason, Ms. O'Hara, why you filed in precinct 3 and not in precinct 2?
Yes, the offense happened in precinct 3 while we both resided there at that time.
Alleged offense. Okay. Which alleged offense? Because you're not suing based on an alleged offense. You're claiming this is as a civil matter that he caused you harm. Okay. And you're saying, at least in the complaint, it says there's a false allegation that was made, a false police report that was made.
That is correct.
Okay,
That led
so
to an arrest.
this is the offense here that you're claiming, right? If in fact there was actual any type of assault, physical assault, according to your complaint, he filed the false allegation that you had committed the assault on him. Is that correct?
Correct.
But you're suing based on the false allegation.
I'm
So
suing on damages and a debt claim that's been unpaid.
So it doesn't say anything in here about a debt claim in your petition.
Yes, I made an amendment to the court. I emailed the court telling them that I needed to amend the original petition, and they accepted it, told me how to do it, and it was emailed back, and they accepted the amended petition. So it should say damages and a debt claim.
Look at the amended.
I do see it was filed May 2nd, 2025.
I'm pulling it up here right now. Okay, so there's a debt claim for unpaid dues. Okay.
Correct.
And then there's damage to property. Where did the damage to property occur?
Precinct 3
Okay.
at 8800 Highway 290 West, Department 1411.
And the debt that's owed,
Same precinct.
because it says for unpaid dues. Is this a membership of some sort?
No, this was a contract from a loan. It should say from unpaid loan. It was a loan that I loaned Mr. Wood, and he didn't fully pay back the loan. And we have it was a signed contract sent by him to me, docu-signed, and signed by both of us.
For $4,000, which you were paid.
But that's okay. That's just an allegation that she's making at this stage. So you don't have to respond to that. All right. So let's take a look here. Okay. Any objection then to hearing the case here?
I'm sorry, could you repeat that? I didn't hear that.
Is there any objection on behalf of Mr. Wood for me hearing the case here right?
I have no objection, Your Honor.
Okay, so we're going to go forward then. So typically we also like to do is I like to give people an opportunity to try and see if there's any chance for resolution. Do you think that there's a chance of resolution if I put you into a breakout room so the two of you can talk together to see if you can reach an agreement, or do we need to go forward with this case?
I would be happy to enter into negotiations with the defendant.
But is that something that you'd be open to doing here, let's say 5-10 minutes? See if we can reach an agreement.
I'm sorry, was that a question for me?
It was a question for Mr. Wood.
Okay.
Your Honor, I don't believe we have anything to discuss.
Okay, not a problem. If I can have both parties please raise your right hand. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth?
Yes,
Yeah.
Your Honor.
All right. All right, Ms. O'Hara, this is your case. So I'll give you an opportunity, just a real brief 30 seconds, 1 minute tops, opening statement, please.
Okay, Your Honor. First off, I emailed the clerk to request the defendant's evidence, and she sent me an email back. And in communication this morning, she stated that she has also not received any of my evidence, and I submitted this on Friday. I'm really concerned about not being able to try a case with my witnesses because they won't be able to see the evidence.
Okay, so here's an issue. This case was specially set for today. Okay, any request for evidence needs to be done well enough in advance so that there's ample opportunity for the parties to exchange, to raise objections, to do any type of discovery, right? Because typically you have 30 days to respond to discovery prior to the court trial. This case has been specially set. So what that means is that if you have not sent that request to him specifically, right? Sending it to the court doesn't do anything because the court, he has to be notified of that. So if you have a motion that you file, he has to be notified of that motion as well. Okay,
I sent it to the clerk and the clerk sent it to the defendant.
well, that's an assumption that we're making that was done because it's certainly not a requirement on the clerk's part to send it to the defendant. It's your responsibility to do that. Okay, so when did you send the request for discovery to the defendant?
I sent the request to the clerk on Friday.
Friday is not sufficient enough time, so I'm going to deny that request. If you wish to proceed, we're going to proceed without any of those requirements because there simply was not enough time for any kind of response to be done in that time period because he's entitled to 30 days.
And I don't necessarily need the defendant's evidence, but what my greater concern is that the court doesn't show that they have my evidence. And I have, I'll just show you the paper copies. This is how much evidence I submitted.
Okay, how did you submit it?
I submitted it by a scanner and emailed it to the court.
Okay, did you scan everything into one document and send that one document to the court?
I scanned it and grouped it into, I believe the scanner did do it in one document, yes.
It's possible, and I'm not saying that this is in fact true, it's possible that that file was too large and it didn't go through.
Yeah, I also did it in separate ones. So I did it in duplicate and I grouped it into, because I looked at the megabytes and made sure that I was under the megabytes there so that the file could send. And it was well under, each one was well under the megabytes.
Where is the email that you sent that attached that? In other words, when you said you did that on Friday, is that correct?
Yes.
Mary, do you have, no, we don't, because everything that I'm looking at here is dated. If you sent it on Friday, it's possible that it's still in a holding area. Is that possible?
If that's the case, do we need to reset this hearing so until the evidence comes in?
Mm,
The reason I
Just
say
a
that,
little-
if you sent it on Friday, Mary, do you see it anywhere in holding, perhaps?
No, I checked all of our inbox. I checked our archived everything. I do not see anything. I asked Ms. O'Hara to resubmit it to us while we were waiting. She said she was unable to. So unfortunately, I don't see that we ever received it.
So here's the thing, because it was done on Friday, what time was it done, Ms. O'Hara, on Friday?
It was approximately lunchtime.
Lunchtime. What is your email address?
messagesmko@gmail.com.
Mary, can you look that up to see if there's,
Mhm. Yeah, I searched up with her email address and as well with her case number. I could not find anything, even in our junk, maybe went through there, could not find anything as well.
so unless you're able to present it now, Ms. O'Hara, I can't consider any of that because it's, you have to be able to present it so that we can see it, right? And Mr.
Yes,
Wood will be able to-
absolutely. So I can question my witnesses.
I would say
So
what-
I understand that this case was specially set today, which means that we did this on Zoom specifically for you all to have this hearing. Now, I can tell you from my experience here is that, in order to prove up your case, you're going to need evidence. And without physical evidence, it's going to be your word against his word. And Mr. Wood, I don't know if you have specific evidence, but that means you're going to have to show it, share your screen to be able to show what it is that you're talking about. This is not a court of record. So it's not like we're recording, well, technically we are recording here because we're live on YouTube, but that will be deleted as soon as we're done here. You know,
Well, Your Honor, I filed my response to this case. I don't know, over a year ago.
yeah, I see the answer. And I think you filed a motion to dismiss as well, is that correct?
Yes, Your Honor, this is nothing but continued harassment.
Well,
Just now it's being tied to a civil case for monetary damages that are not owed.
has there ever been a hearing on the civil case? I
This
mean,
is,
sorry, on the motion to dismiss.
I was not ever, I sent it in, all I ever got back was that it was reset. So I
Yeah,
never
we
heard a ruling on my motion to dismiss.
Judge Olivo, we did send it to our Judge Holmes for review. She stated that the case just may be set for a TBC and proceed as normal. That's what the note stated.
Oh, but there was, she never heard the motion to dismiss, is that right?
Yeah, it says no action needed by court on this defendant's motion to dismiss.
All right. So he basically ruled on that.
It was Judge Holmes.
Yeah, that's what I'm saying. Judge Holmes ruled on it already, basically,
Mhm.
that in essence, he's denying the motion to dismiss.
Yes, essentially.
Okay. Um,
And Judge Olivo just says I could Miss can share her screen if she has the documents on her phone, to see if she can do that as well.
say that again, it kind of cut out, sorry.
Oh, Ms. O'Hara can share her screen with the evidence if she has it on her phone or like the device she's
it's all in paper.
Yeah,
but the scan, she said you scanned it.
Yes.
That scan
I tried to
copy.
get the evidence from the scan so I could share it on the screen during the break while we were waiting, and I wasn't successful so
yeah.
far.
Unless that scan is actually saved on her phone, she won't be able to go to the phone to open it.
Mhm.
So she would have to like put the camera on it in order to see it and hold on to it. All right. As I mentioned to the case before this one, I do not like pushing these cases down. But I can tell you that the only evidence I'm going to be considering today is the evidence that is presented orally and that which is already in our system that we've already received. I cannot consider anything else because we don't have anything else to consider.
Your
That
Honor,
makes-
would we be able to do a motion for continuance because of this, because you guys did not receive my evidence? Because it's very important because I can show that
I
how
understand.
many occasions that the defendant is lying and will lie.
I want to clarify also, the motion for continuance is not based on we didn't receive it. Right? Because if it was sent, we would have received it. So the motion for continuance would be based on some error on your side, not getting it here. And then because each side, generally, we're going to grant a continuance. And it looks like Mr. Wood requested a continuance in the past, and we granted that. Actually, each of the parties have requested a continuance in the past.
Yes.
All right. So I don't know the basis of that, other than that both of you have requested it. So if you're both in agreement to continue this case, it's gonna have to be specially set again. And it's gonna be down the road. It's gonna be at least 2 months down the road. It's not gonna be next week.
Okay.
Your
And
Honor, I'd like
I'd
to
be
get,
willing to see this in precinct 2. I'd be more than happy to do that in precinct 2 where he lives currently.
Then you'll have to file a motion to change venue. To put it back into the precinct where he lives, which is.
Okay, is that what we would need to do is, would I need to do that to file a motion to change venue?
Either one of you can do that.
Okay,
Your
okay.
Honor, I would just assume to have this case ruled on now. I don't have time to go through her hundreds of pages of whatever it is.
You're opposed to the continuance at this stage.
I'm opposed to the continuance. I had to take a day off of work. I'm tired of this hanging over me. It's just yet one more form of harassment.
Mary, tell me about the setting on this, because as I understand it, it was specially set. So we went out of our way to set this specifically today. Is that correct?
Yes.
Y'all
Oh.
picked the date.
No. Well, that's why I'm asking the clerk, is because she has notes as to the history on why this case was set today specifically. In other words, we can take any date, right? But both of you are appearing by Zoom. You're not here in person. So we went out of our way to make these accommodations for the parties today. And so
Yes.
that's what I'm trying to find out. What's the basis for that? And so Mary, the court clerk, is telling me that it was specially set, which means that if there's an objection to a continuance, then I have to take that into consideration.
Well, Your Honor, the reason I did not want to do this is I have no desire to be in the same room with Ms. Clara. All this results from yet another physical assault by her on me.
Okay.
It's taken me thousands of dollars of
All right.
therapy.
Sir,
I don't want to be with her.
Mr. Wood, I'm going to give you an opportunity. All right, so this is what we're going to do. We're going to go forward. I'm going to deny any type of continuance. We're not going to be, I'm going to deny any requirement for any discovery at this point in time. We're going to move forward. I've already sworn each of the parties in. Ms. O'Hara, as I asked previously, give me a quick 30-second to 60-second introduction. Just why are you here? Why are you demanding that Mr. Wood owes you money? And then we'll move on to him.
Okay, thank you, Your Honor. Yes, we are here because there was a false accusation made that led to a dismissal. The court record states insufficient evidence, upside down case. That rendered me suddenly homeless. And all this occurred right after I had Achilles tendon surgery, was not able to walk, was not weight bearing. I incurred extensive amount of debt, attorneys, hotel fees, emergency housing fees. My insurance, we were on the same insurance policy. Without notice, that was suddenly cut. And I was in the process of extensive physical therapy 3 times a week. So I had to pay that out of pocket. I had multiple, I wasn't able to drive because it's my right foot. And I had to obtain Lyft rides in order to get to physical therapy. 2 physical therapy appointments were canceled, which I was charged for. My knee scooter was also taken when I was arrested, and I was not able to walk. Therefore, I had to go to the hospital right after. I'm not asking for that, but there are medical expenses due to the fact that I had to pay them out of pocket that were already, the appointments were already set prior to the false accusation. And also there was a contract debt that was not fully paid back with the interest fees that Mr. Wood stated in the contract. And in Mr. Wood's response to the court, I can prove that all 4 of those points are fallacies, lies with my evidence. And also Mr. Wood filed a continuance. We had a hearing set for December 9th, which I also took that day off. Mr. Wood stated that his reasons for continuance said he was out of town for his daughter's graduation. I have facts showing that he was actually in Austin, Texas at work on Ranch Creek. He was working, he was in town. His daughter didn't graduate till Saturday, and he had not left town yet. So he could have gone to that hearing on December 9th, and I took that day off as well as today.
Issue of the continuance on the hearing has no bearing on this case whatsoever. And so I'm not going to hear any evidence with respect to that.
I understand.
Because we're here just simply because you're claiming that you've suffered damages as a result of Mr. Wood's actions. Okay, so that's it. That's what we're here for today. Okay.
Thank you.
All right, Mr. Wood, real quick brief, 30 seconds to a minute. Opening statement, please.
Your Honor, in the incident that happened on February 20th, 24. The decision to arrest Miss O'Hara was not made by me. It was made by the Travis County Sheriff's Department. They took pictures of the handprint on my face, the whole 9 yards. This was not the first time I was assaulted by Miss O'Hara. It was just the straw that broke the camel's back. The Travis County CA advised me to leave, claiming domestic abuse. I had to rearrange my life, terminate my lease, establish a new lease. I handled all the moving expenses. I've even paid for 6 months of storage on Miss O'Hara's storage unit when and that was based on her breaking in and stealing things out of the storage unit that I had by cutting the locks off of them, which is documented in another Travis County Sheriff's investigation. I just want to move on with my life. I'm not seeking any damages against Miss O'Hara. I just want her out of my life and to move on with hers. It has been 2 years. The continual harassment, I have been signed up for everything from Tinder to Grinder to, I mean, just little annoyances, calls to my work. I just needed to stop, and I just would like for her to go away and live her life. Let me leave mine.
Just to kind of give you both a little bit of understanding, the general rules of civil procedure don't apply in this court like they normally do in other courts. So with that said, I'm going to give some leeway in terms of evidence that's presented. You still need to object. If you object to a particular thing, I will rule on those objections, make sure that if somebody makes an objection, you allow me to respond to that objection before you continue giving evidence or talking or testifying, okay? With that said, I will be, in order to move this case along, and not to get into any tangents, I'm going to be asking some questions of each of the parties to kind of guide you. In a sense, I'm not going to be helping you, but it's based, questions that were based on things that I need to know from assumptions that I'll be making from the petition, from the answer on where it is I believe that you're trying to take your claims. Okay. All right. With that said, Ms. O'Hara, you may begin.
Yes, 1 moment here. Okay, my apologies. Yes, in regards to, first off, I have a motion to dismiss, that was accepted, upside down case.
Okay.
File stamped by the court. I also have, in regards to Mr. Wood's claim about paying for storage, that's not true. Oh, I'm sorry. Go ahead, sir.
Are you asking that that document be entered into evidence?
Yeah, that's what I sent in, or yes, I apologize. Yes, that's what I submitted in the scanned documents. How would I do that now?
So if you'll put that document back up again, just kind of hold it there. Mr. Wood, if you want to take a look at that, it says motion to dismiss, and it's the county attorney has signed that to dismiss the assault family violence charge. See that?
I actually cannot see it, Your Honor, but
You can.
I find it, I was,
A little bit maybe.
let me see, it's got a bar across it on my screen. I cannot read that, it's way too small. Your
I
Honor,
can try to put a spotlight and see if that works.
I was never informed about the hearing date because I would have gone to that hearing. And I was never even given a chance to tell my side of the story during that procedure.
Objection incorrect.
So your objection is overruled. So Ms. O'Hara, you're presenting a document saying that the case was dismissed, and you're also making allegations that it was dismissed because it was false. That's not true either, okay? The only basis for that document being entered into evidence is to prove that in fact the case was dismissed. That's it, nothing else. There's nothing about this document that would suggest why it was dismissed or who chose to dismiss it, under what circumstances, whether Mr. Wood was consulted with it beforehand or not. The only thing this document does is provide evidence that the case in fact was dismissed. That's it.
Yes, it states the reason as well.
Yeah, but that has nothing to do with
Okay.
anything here. It just means that the case was dismissed. So, Mr. Wood, is there any objection to this document simply that the case was dismissed? That's the only thing that I'm considering that document for.
I object to it simply because I was never informed of that case. When that case went to trial, I was never even given a chance to do it.
All right, so I'm overrule that objection. Again, you being advised of it is not the question that I'm asking. I'm asking, do you object to the document itself, that it states that the case was dismissed? We're not talking about why it was dismissed, how it was dismissed. The only thing is that it states that the case was dismissed. That's it. That's the only thing I'm considering about that document.
I guess I will accept it.
You're going to accept it, and Ms. O'Hara, make sure you make a note that document needs to be sent in. Now, my question to you, Ms. O'Hara, what does that document have to do anything to do with this case?
It's one piece of evidence showing that it was dismissed, cannot be proved beyond a reasonable doubt, case is upside down. And the DA dismissed it, not my attorney.
Again, what does Mr. Wood filing these charges against you have to do with your damages?
These charges basically is why I incurred over $20,000 of debt.
So if you incurred more than $20,000 in debt.
Yes, I'm only asking for 19,500 though.
Okay, but you don't get to say, I incurred more than 20,000, but I'm only asking for 19,000. Therefore, it falls in the jurisdictional limits of the court. If you incurred more than $20,000 in debt, this case needs to go to a different court and we don't have jurisdiction. It's as simple as that.
Okay,
It's not what you're asking for. It's what the damages that were caused that determines whether we have jurisdiction or not.
which court would this need to go to?
We would go to the county court of law or the district court. But we would not come here because we have a.
Okay, would I requesting your information, but would this case still, because it was filed, would it still fall under the statute of limitations?
I don't know when this happened. There's a 4-year statute of limitations when it comes to injuries. Okay.
Okay.
Some type of personal injury. I don't know that that's what you're claiming here because your petition is not clear. This is not a breach of contract. Now you do have a breach of contract issue because in your amended petition, you filed the issue of a debt. Okay?
Yes.
And so that is a breach of contract. That's a 2-year statute of limitation.
Okay, and when I filed this, and part of the reason I chose to do small claims is I didn't want a lengthy litigation. And the documents that I have here show the debt of under 20,000.
What was the debt incurred?
The debt incurred are medical fees, counseling fees, hotel fees for housing.
Hold on. You claimed earlier that there is a loan that you gave him that he owes you for.
Correct, a $4,000 loan, he paid half without the fees and the interest.
When was that loan entered into?
That loan was entered into, let me get my evidence here. One moment. May 5th, 2021. And the statute of limitations on debt claim is 4 years.
No, that's not correct. Statute of limitations on this is 2 years on a loan that you've given to him because that's a breach of contract. And when did you file this case?
I filed this case February of 2025.
25. Yeah, so that's more than the 2 years. And so any claims that you have with respect to an unpaid loan are hereby dismissed because it does not meet the statute of limitations. So we're not going to talk about any of that whatsoever. Okay. Let's talk about, when did the injury occur that you received that caused you to spend all this additional money because of your
February 26th, 2024.
2024.
Correct.
All right. So you're still within the 2-year statute of limitation if it falls into that. I'm still not convinced that this is a personal injury type of a case, because you're claiming damages, but you're not claiming the damages from him assaulting you. You're claiming that because of his allegation of the assault against you and you were arrested, that's what in fact caused you to lose your home, to incur medical fees and all that. Is that correct?
Yes, as well as not having, he took my knee scooter from jail and I wasn't able to walk. So I fell about 10 steps outside of the jail after being released.
I think you walked through the jail.
I'm sorry?
Well, you were in the jail for how long?
6 days.
6 days. How did you walk without that scooter?
I didn't. I was non-weight bearing. They brought me a wheelchair. Once they brought me inside, they issued me a wheelchair and allowed it to stay in my room.
And
I was
then
not able to walk.
Did they walk you down to the door?
I wasn't able to walk. They came in and asked me if I was able to walk unassisted, and I said no. And I asked them if they had if I could use the wheelchair or a walker or something, and they said no.
Just to be clear, Ms. O'Hara, you're going to have to show approximate cause between your injuries and his actions, okay? And the fact that he did not, or that he picked up that little scooter, that did not cause your injury when you fell down 10 steps later, okay? I'm just going to tell you that right now. If he pushed you, or if he took it away from you while you had it, then that's approximate cause, okay? But when you took those 10 steps without it, you did that of your own accord. There is not an issue here of proximate cause that because he picked up that little knee scooter, therefore you fell down and that's where you suffered an injury.
Your Honor, may I speak?
No, sir. All right, Ms. O'Hara. Let me go back a step so I can better understand. Were you all in a relationship?
Yes, we were, and at the end, we were just
Were you
roommates.
living together?
I'm
Pardon?
sorry? Could
Were you
repeat
living
that?
together?
Yes.
Okay. Did this breakup result in you leaving, Ms. O'Hara?
No, the breakup, because there was a prior accusation made by Mr. Wood that was also declined. The charges were I was never charged on that. It needed to be expunged. And Mr. Wood said I could rent an apartment.
Okay, when did you all split up?
February 20, we broke up the relationship as a boyfriend-girlfriend relationship in September of 2023.
Okay, and the allegation, so what caused you all to be together again in February of 2025? Or
My
2025?
case in Hayes County from his accusation, he was strangling me, so I did bite him in self-defense to get away. Was not finalized yet.
So hold on, you said Hayes County.
Correct.
So all of this happened in Hayes County?
No. There was one incident. I had COVID. I was hypoxic, meaning low oxygen. And Mr. Wood was very combative. He put me in a chokehold headlock. I bit his arm to get out for self-defense, asked him to leave the apartment, which he did.
What does that have to do with you losing your home and having to go into the Safe Alliance and incurring medical injuries because of your foot when you were in jail. What do those things have to do with that?
I wasn't going to bring it up in this case. Mr. Wood did in emailing to the court.
Okay, so the Hayes County case has nothing to do with this.
I don't believe it does, no.
Okay, then we don't need to speak about that. So let's
Okay.
move forward to then the case that you're claiming where he made the false allegation. That was in February of 24, is that correct?
Correct.
Okay. According to you, he makes a false allegation and you get arrested that day, is that correct?
Yes, and I can provide a motive that he wanted to get out of the apartment lease without penalties.
Okay, but that motive has nothing to do with this case.
Okay.
So, all right. So you get arrested that day in February 2024.
Correct.
You're in jail for 6 days.
Correct.
And that's here in Travis County.
Yes, sir.
Okay. When you get out of jail, you fall down and injure your foot.
I'm not, those aren't the injuries that the medical expenses that I'm requesting. I'm requesting medical expenses for missed physical therapy appointments and out of pocket, suddenly having out of pocket, having to pay for physical therapy 3 times a week, plus the 2 missed appointments.
He caused you to miss those appointments.
Because he made the false accusation that led to an arrest.
Okay, so were you in jail and that's why you missed those appointments?
Correct, Your Honor.
So you missed multiple physical therapy appointments and you missed other doctor's appointments all in that 6-day period.
Yes, sir.
All right. Tell me more about your case.
Okay. I was in touch with I had Achilles tendon surgery right around New Year's of 2024, a month and a half prior. During this time, oh, I'm sorry.
Did the Achilles tendon surgery have anything to do with Mr. Wood, or that's just something that you had done separately?
Yes, there was abuse was becoming abundant by Mr. Wood, such as neglect, such as he filed me on his IRS taxes against my consent or knowledge.
So Harry, we're getting off on the tangents here.
Financial abuse.
Did Mr. Wood have anything to do with you having to have the tendon surgery?
No.
Okay. All right. So I don't need to hear about all those other things.
Okay.
All right. So you had tendon surgery. Okay. And that's the reason that you had foot problems. That's right?
I'm not sure that I understand your wording. Could you repeat that?
So you had the Achilles tendon surgery for some reason other than anything to do with Mr. Wood.
Correct.
All right. You had that surgery done when?
December 28th, 2023 to be exact.
Okay, but it was in 25 when you had this, when you got arrested.
No, 24. So it was approximately 2 months.
Late.
2 months after surgery.
Okay, so 2 months after surgery, so you're still doing rehab on that. Okay. You get arrested, so therefore you can't go to some of your appointments.
Correct.
All right. Now you claim that you're no longer on his insurance and you had to pay out of pocket.
Yes, and I was not informed of that at all. I found that out by going to physical therapy. I'm sorry?
Were you married to Mr. Wood?
No, I was not, but he claimed that I was on the lease agreement and other areas he claimed to people in public that I was his wife. He identified me as Mr. Wood on his lease to the leasing agent or Marsha Wood. My name has never been Marsha Wood.
What obligation did he have to provide insurance to you?
He didn't. It was an agreement. It was actually an offer that he wanted so that I would sign him onto my lease at my first apartment.
Were you all living together? Because you told me you were not living together.
We were living together in Austin and many years ago, and he said that if you will let me live with you, I will claim you as a dependent on my insurance.
And at this time, when you got arrested, were you living with him?
Yes, I was.
Okay, so you all, because I asked you specifically if you were living together, and you said you were not.
I apologize, incorrect. We were living together.
So in February of 24, you were living together.
Yes, as roommates.
Okay. But as roommates, or were you having a relationship?
As roommates at that time, we broke up our romantic relationship September of 2023.
Okay. All right. All right, you may proceed.
Okay, me?
Yes, ma'am.
Okay, I just wanted to be clear. Okay, I have some witnesses to question that are waiting in the queue.
And what witness is going to testify about?
I'm sorry?
What are the witnesses going to testify about?
The witnesses are going to testify. Mr. Wood reached out to one witness, a licensed professional counselor of mine, attempting to create a narrative, and her notes that have not been altered since the date of that. And he was also threatening to call 911 because he knew I had a prior arrest.
What does this witness contribute to him owing you damages?
This witness contributes by showing manipulation and abuse prior to the arrest.
But you're not suing him because he manipulated you and abused you. You're
Yes,
suing
that
him,
is why I'm suing him.
but that's not what it says on your petition, and that's not clear. What you're suing him for is you're saying that because of his actions of filing a false police report and that you having to go to jail, that therefore you incurred expenses as a result of that.
Yes.
That's what you're saying. That
And prior to the arrest, expenses with I need to hired a tax attorney to straighten it out because of the federal tampering of that's not the correct word, but claiming me on IRS, taking my social security card, which I've never provided to him. And that I've incurred costs for that
Did you hire a tax attorney?
Yes, I hired a friend that's a tax attorney. Yes.
And did they represent you to have your taxes redone?
Yes.
So did you pay someone to refile your tax return?
Yes, I did.
All right, make proceed then.
Okay. I have evidence showing that Mr. Wood is actually the hostile one. There's a police report that he was aggressive with his son, broke his son's phone.
Ms. O'Hara,
There's another police.
those things have nothing to do with your
Okay.
claim. So
All right.
I don't want to hear those things.
Okay. On the scan, I had multiple missed appointments and cost incurred. I went to counseling through a licensed professional counselor at $120 a counseling session once per week due to I was diagnosed with post-traumatic stress syndrome disorder.
So, one moment. Were you seeing a counselor prior to your arrest?
I was seeing a career counselor prior to my arrest.
And you went to a different counselor afterward?
No, same counselor.
Okay. How long have you been visiting that counselor prior to your arrest?
I was visiting her approximately 2020.
But you said this is a career counselor. What is a career counselor
She
do?
changed to a career counselor. She's a licensed professional counselor.
Okay, is she the one that you have in the queue?
Yes.
Okay, let's go ahead and bring her in.
Okay.
So Mary, if you can bring her in, please.
Your Honor, can I object to this?
What is the objection?
What bearing does this have on this case?
Well, that's what we're gonna find out. So if you can state unequivocally that it has absolutely no relevance whatsoever, then show me how. Otherwise, I'm gonna ask the counselor so that I can get an idea of what kind of testimony they're gonna present before I even allow the testimony. So, Ms. Williams, are you the counselor that she was talking about? You've been in here the whole time?
Yes,
Okay, let me have you raise your right hand, please. You solemnly swear the testimony about to give will be the truth, the whole truth, and nothing but the truth.
yes,
All right, I'm gonna ask you a few questions just to kind of get to where we're at. I do not want you to give me any type of privileged information of any sort. Okay, I'm just trying to find out, first of all, what kind of counselor are you?
mhm. Yeah, I'm a licensed professional counselor. I'm qualified for general counseling and I specialize in career counseling.
Okay, especially career, and so what does career counseling entail?
In my case, it's a very holistic approach to just all the roles in one's life and helping them work together to be the most purpose-oriented aspect of your life.
What type of education have you had to get you to this point to be a licensed professional counselor?
Yeah, I have a master's in counseling
I'm assuming a bachelor's in
in psychology.
psychology. Okay, how long have you been doing this?
I got my license in 2013.
Now, with respect to Ms. O'Hara,
Mhm.
I don't want you to give me any privileged information, but simply, let's start with, when did you first start seeing her as a client?
With the first counseling center, because I've moved several times, that goes back to, I think, 2015.
And you indicated that you specialize in career counseling.
Mhm.
Were you giving career type advice to Ms. O'Hara? Is that what you were counseling her on?
That's one of the areas that we were working on, yes.
Okay. Were you working on other areas? What other areas were you working on?
Her general mental health and anxiety and dealing with the stressors in her circumstances.
And these are things that have been going on since 2015, that you've been doing that type of counseling as early as 2015.
Yes, and the issues that she would work through have changed over time.
Okay,
Well, some have accumulated.
all right. Now, you've seen her regularly from 2015 until a period of time she was arrested. Is that correct?
Yes,
And so when she was arrested, that was in February of 2024. Is that correct?
that's my understanding, yes.
Did she miss an appointment with you during
No.
that 1 week? Okay, so she didn't incur any additional costs with respect to missing an appointment?
No.
Okay, now, since that date, have her visits to you been similar to the type of counseling sessions that you had with her prior to that arrest?
The nature of symptoms, yes,
How often do you see her?
usually once a week.
Once a week, and you've been seeing her once a week pretty much this entire time?
Mhm.
Okay.
Yeah, brief hiatuses, but that's, I was on maternity leave once, yeah.
Do you receive insurance? We accept insurance payments?
No.
So everything is paid in cash?
Yes.
Thank you very much.
Yeah.
Ms. O'Hara, this witness is not going to provide any information that is relevant to your claims that he caused you these damages. Okay, so I'm not going to take evidence from this witness for that purpose in terms of any of those other types of claims. Okay?
Your Honor,
Yes, ma'am.
this witness can prove manipulation because this witness directly contacted this witness and manipulated and presented a narrative and manipulated her into trying to believe something that was not occurring.
So you're telling me that Mr. Wood manipulated your counselor into doing something that she would not otherwise do?
Correct. I left the apartment after
Well,
he
hold
was
on.
hostile and he was
Miss O'Hara, you have to stop. Miss Williams, did Mr. Wood contact you and manipulate you into acting in a way that you otherwise would not have acted?
I wasn't manipulated into action. I did experience an attempt to manipulate me.
Okay, but you didn't do anything as a result of it?
No.
Okay, all right.
Well, Your Honor, she called me.
Ms. Williams, you are free to go.
Okay.
You don't have, I mean, you can stick around if you want, but your services are no longer.
Okay.
All right, Ms. O'Hara, I need you to get to the point, because you have not presented anything at all that would suggest that Mr. Wood is the cause for you having to spend additional monies for treatment to your foot or for anything else.
I also incurred expenses for movers. The initial down payment was $99. And that's the paper I have. In the scanned document, it was approximately $500 due to the fact that when I was at the storage unit separating my things, and by the way, we both had consent to enter that unit. And both of our names were on it. I was moving my things and separating them to my own unit. Mr. Wood showed up. There was a 30-day protective order. I advised him we're not allowed to be 250 yards from each other. Please step away. He did not. I was pinned in a corner. He was very hostile, yelling and screaming. So therefore, the movers were there for a lot longer. And so my total bill was approximately $600 combined with the down payment and the length of time they had to stay.
You all shared a rental unit, right? We're talking about storage units. Is that what you're talking about? Or is this?
Correct. And also the storage unit waived 6 months. Mr. Wood did not pay for the 6 months of storing my items. He is lying about that.
Were his items in the storage unit?
Both of our items were in the storage unit.
And was he required to pay the full rent on the storage unit?
We were both paying it.
Okay, so you're saying he didn't pay his share? You paid yours?
The unit was, he was the primary under the unit, and I was allowed access. And I was listed under allowed access,
You didn't
but
pay
I was
any,
not on the lead.
you didn't pay any rent on the unit?
I paid him.
You paid him, not liable to pay any. So what have you lost?
What I lost was the moving expenses and having to get a separate one. And
And I don't mean to belabor this point, but you guys don't have a relationship. You have a unit that he's responsible for paying, that you're paying half, right? And now you all have broken up and you want him to pay for you to move your things out. Show me where he's obligated to do
I
that.
would not have had to hire movers had he not made a false accusation.
The false accusation, man, has nothing to do with anything. He made an accusation, right, that you assaulted him. I'm not here to decide whether it was false or not false. The assistant county attorney signed a document saying that they didn't feel that they could prove the case. It doesn't mean that the statement was false. It just means that they didn't feel they could prove it. Okay? So that accusation is not the basis of you having to hire movers. I need you to present to me evidence that his specific actions are the direct cause of your damages. That's what I need to see. That's what I need to hear.
Okay. I went to my doctor's office and was diagnosed with PTSD. I paid that out of pocket. I paid $120 each week for counseling because I was struggling with nightmares, night terrors, post-traumatic stress disorder, anxiety.
All of those things, ma'am. Because for now, as far as I'm concerned, you're suffering those things, perhaps because of the arrest and having to spend the 6 days. And I can only imagine that that's a very difficult thing to do. But how is it that he's the cause of your PTSD?
Because I spent 6 days in jail on a false accusation. My dog was taken from me. My Pembroke Welsh Corgi was taken from me by Mr. Wood, and I am the sole owner of this Pembroke Welsh Corgi. And Mr. Wood was attempting to rehome my dog. I had to file a police report in order to get my dog back.
And I'm sorry to hear that, because I understand how pets are very important to people, and how for emotional support or any number of things on how,
Thank you.
you know, I get that. I understand. And that can be difficult. But with all due respect, ma'am, you don't have a case here. This is a breakup gone bad, and you're blaming him for it. And you're upset that he filed charges against you. And I can tell you, I've been a judge for more than 20 years, and I've been a criminal defense attorney for longer than that. And I can tell you that of the more than 2,000 family violence cases that I've defended, okay, that the vast majority of them had some false allegations in them, okay? But even so, you know, it comes down to a number of different issues. The two of you just simply don't get along. And after your breakup, you clearly should not have been living together, even as roommates, but you chose to.
No, and I wouldn't have, I was only living with him until my other case was eligible for expungement and dismissed in Hayes County. That is the only reason why, because I was not able to rent an apartment. I was staying in an extended stay.
No, and I understand that, but if you had an emergency protective order, you shouldn't have been living with him anyways.
We were not. That was after the arrest.
So you opted to live with him after those issues had occurred.
No, incorrect. There was a 30-day protective order issued
And
after the arrest, February of 24.
And that expired, and then did you move in together again after that?
No, absolutely not. No, I'm in a much better place not being around that man.
And I'm sorry, I don't see any circumstance here, any situation
Well,
where he caused your damages.
would this make a difference? I had to liquidate my 401k with Charles Schwab in order to pay for the new expenses, the unexpected expenses of hotel and other lodging and healthcare. That was totally unnecessary. I had to liquidate my 401k for this.
You did not get along. He filed a criminal complaint against you. The police department, sheriff's department, whoever decided came in, for them it was sufficient to say this is enough to effectuate the arrest. Okay. You were not in a good place. You should not have been together in the first place. Okay.
No.
You're already broken up. You already were not getting along. You already had prior history. You opted to stay there, right? Up until the arrest, right?
Because he threatened that if I did not stay with him, that he would change his story with Hayes County, and then I would then be charged with the
expenses, okay, are expenses that you incurred because the relationship didn't work out.
The
That's-
expenses incurred was because of his lie of a false accusation.
Well, let's assume for a second it was a lie, okay? The sheriff's department believed enough evidence existed at the time to arrest you, even if it was a lie.
I was very calm when they came. There was no physical contact or yelling between Mr. Wood and I that day. And I had 3 written keys in the apartment that proved this.
Ma'am,
And
I'm asking you to provide to me something independent of Mr. Wood's actions that caused you to suffer this harm. And you're saying that because he lied about the physical
I have
assault.
hotel expenses.
Stop, because you're saying because he lied about it, that therefore you were arrested. And because you were arrested, you missed a number of appointments, physical therapy appointments. Okay?
Yes, I had to
Miss-
obtain emergency.
Ma'am, stop. Missing those physical therapy appointments did in and of itself did not cause you to pay any additional fees. You fell when you walked out because you didn't have your little scooter for your leg.
Yeah, that doesn't matter.
Right. And again, there's no tie, there's no nexus between his actions and the cost that you incurred, right?
Incorrect, because I had to get emergency lodging, which was approximately $3,300 a month at extended stay hotels.
How much were you paying for rent?
The rent for the apartment was $1,700.
You were splitting that? Or
Yeah.
you're paying 1,700?
We were splitting it.
Okay, so you needed to go find another apartment. Your claim is that you couldn't find another apartment because the expungement hearing had not occurred yet on the original case that you had with him.
That's what he told me, is that I wasn't able to rent a car, an apartment, or get
So
a
he
job.
told you you couldn't.
Yes,
Did you try
And-
to rent an apartment?
yes.
And why were you denied? the
Because
ability to-
I had an arrest with 2 felony counts and a misdemeanor
Okay,
in Hayes County.
all right. Ma'am, I'm going to dismiss your case. There's no evidence here whatsoever to show that Mr. Wood is responsible.
What
for-
about the hotel fees and suddenly having to get in a mailbox because I was homeless due to his actions
Ma'am,
without warning?
All of these things have to do with a bad breakup. And because of the prior history that you all had, the physical history that you all had in Hayes County and in Travis County, enough so that you didn't have a relationship anymore, but you were still living together. So these are all things that you did knowingly go into a living situation with him.
I didn't
Right.
have anywhere else to go. I stayed in an extended stay, and Mr. Wood begged me to.
Was the lease in your name? Was the lease in your name?
No,
was it-
the lease was in his name, but I was the lease apartment
They
leasing
knew
agent
you were
was
living
aware
there.
that I was there.
Right, and that's fine, but it wasn't in your name. You weren't liable on the lease. If he didn't pay, they weren't gonna come after you, they were gonna go after him.
Correct.
Right, okay. You would have had to pay rent anywhere, regardless,
Correct.
right? The fact that you chose to go to a hotel or someplace else, I get temporarily, but
That
you're
was the
saying-
only place that I could rent.
Okay. I'm sorry, ma'am. There is no evidence, none, not a scintilla of evidence to suggest that he's responsible for these injuries or these damages you claim to have incurred as a result of him making allegations against you. There's no.
What
nexus-
about the out-of-pocket physical therapy fees, the out-of-pocket for Lyft rides because I no longer could get to physical therapy?
Well,
The
I
out-of-pocket.
did physical therapy before. You said because it was your foot, it was the right foot.
Yes, actually, both of my feet are damaged. I was
You had
supposed to have
to
surgery
take
on
them
both.
both ways, right? Because you had the surgery 2 months before all of this happened. How were
Yes.
you getting to those appointments prior to you being arrested?
Mr. Wood agreed prior to the surgery to drive me.
And so now he's not driving you because you guys don't get along
No,
anymore.
he wasn't driving me towards the end. It was neglect.
So he wasn't, so how are you getting to those appointments towards the end?
I wasn't. I was trying to get Lyft rides. I was trying to get people in the community to help. I
No, ma'am.
wasn't.
No, ma'am, that's on you. You can't tell me that he caused you to miss appointments because he didn't want to take you because you guys aren't getting along.
The appointments that were missed that I'm referring to are after when I was arrested.
Right. But you also just told me that towards the end, he was neglecting you and he was not taking you to your appointments.
There was neglect in many forms, actually.
But he's not obligated to take you to these appointments, right? You're not married. There's not a relationship here anymore. You live together. He
But
was
we had
doing
an agreement prior to surgery.
And what did you do in return for the agreement?
In return, I kept the house. Did his laundry. I cooked all the meals. I did the grocery shopping.
That's not a contract, man. So there's not an agreement there. There's no consideration for him to take you to these appointments that he's required to do so. But there's nothing, you have no claim here, ma'am. I'm sorry. You simply do not have any claims here. Now I understand how difficult this is for you. I understand that emotionally you've suffered through this, but you had a bad relationship to begin with and you opted to stay in it.
Well,
Right.
I just thought of something else. I forgot. I apologize. I do have some damages because on the first arrest, Mr. Wood was not on my lease. I actually had another person on the lease because I did not want Mr. Wood living with me. We both contracted COVID for my daughter because Mr. Wood lied to the police officer, and also because I bit him in self-defense. I was arrested,
Yeah.
and there's a fees involved in breaking that lease.
You're talking about the Hayes County issue.
Yes.
And we've already agreed that I'm not going to hear anything to do with Hayes County.
Okay.
Right, so that has no relevance here today. I'm dismissing this case. You just simply don't have a claim. All right, good luck to you all.
Thank you, Your Honor.
Thank you, Your Honor.